So, Thibault Schrepel, assistant professor of Antitrust at Utrecht University and faculty associate at Harvard's Berkman Klein Center, will deliver a presentation on predatory innovation and Codice law. Thank you, Thibault, for being here despite the strike, and the floor is yours.
Okay, is it working? Yes, great. So first of all, I do have to apologize for being late. I hate that, although I'm French. So sorry for that. I do have to say also that I'm really happy to be here for three reasons. The first is the panel. I mean, what a panel here, so I'm really humbled to be part of this panel. The second reason is that Rome is one, if not the most beautiful city on planet Earth, in my opinion, so I'm really happy always to be in Rome. And the third reason is indeed what a trip I had. There is a major strike in Paris, so I was stuck in the airport for 6 hours, which is always lovely. But eventually I made it. So again, very sorry to be late. Yes, without further ado, I do also want to say that I was in Venice 2 weeks ago for the Biennale, and I thought that it was interesting to see the way they actually displayed Italian artists, and I thought that they had like a good spot here and there. So maybe it's a proof that self-preferencing is a good thing, I don't know. But yeah, I thought it was a beautiful Biennale. So happy to discuss that even more. And by the way, Citizen M Hotel is a good hotel, so I didn't know the French Competition Authority was paying for good hotels. Anyway, so what I want to discuss today are two different things that I will try to tie together, and I will tie myself. The first is predatory innovation, and I will explain what I mean by that. The second one is a new way to approach the law, and I will apply that to antitrust competition law. The theme of the presentation being, of course, those two themes, but also generally I do talk a lot about music, but I had the feeling that maybe Philip will talk about music, so the theme for this one will be movies. So let's get started. So two things. First, I want to explain what I mean by predatory innovation, if it is relevant for antitrust or competition. And the second one is to be a bit more broad about some issues that I think are missing in the report and in the enforcement of competition agencies. But that picture, because I'm really intimidated to be part of a panel with you, Philip. You are known as the best speaker in Europe, if not elsewhere. So I'm gonna be small today. All right. So first of all, predatory innovation. So what I mean by that, so there is no official definition of that. It was the definition I wrote about in my PhD a few years ago. So predatory innovation, the way I see it, is the alteration, so the modification of one or more technical elements of a product, not to improve the product, but to eliminate competition. So you may think, wait a minute, if you say that it's not a way to improve the product, but just a way to kill competition, it's not really innovation. But here, so there, of course, there are many definitions of what innovation is, but I think we can agree that the two manuals published by the OECD, the Frascati manual and the Oslo manual, are the one that we should take into account, and they make it very clear that innovation is just something new. It doesn't have to be better. It is just something new. So in that sense, predatory innovation is a sort of innovation, but it's a bad innovation. And of course, companies, if they do that, they won't ever say it. They will pretend because it is new, it has to be great, which is also probably a bias that we all have. The two effects of that, but I will discuss a bit more. The first is to remove compatibility, interoperability with third companies. And the second one might be to impair the functioning of third companies' products with the one of the dominant firm. But so before, very brief on that, a bit of history. I'm not the creator of that concept. It appears more than 100 years ago. It was, for the first time, there is a paper dated from 76 discussing predatory innovation in antitrust coming from the US, and then those three articles, those are the three big articles discussing predatory innovation for the first time. And then pretty much nothing for almost 30 years, which is still a mystery to me. However, if you look at the general literature using Google Ngram, you could see that the trend is definitely growing. Unfortunately, it stops in 2000, and I'm sure that when we're going to have the data, we're going to see more and more for the reason that I will explain. Predatory innovation in practice, so where do you see that? I think it's useful to make a distinction between two types of predatory innovation. The one made on platforms. Of course, there, as you know, we have to take into account the characteristic of platforms, mainly two-sided platforms, switching cost, lock-in, and so on, and predatory innovation made outside of platforms. Something I want to mention is that when we hear two-sided markets and we read Jean Tirole, we think about maybe social media, that kind of stuff. But it could also be, for instance, a browser. They could be two-sided market in the sense that you could actually plug add-on, so those little software to your browser, and you do have another face in the market. So it's a bit more broader than what we hear. But so I think here what is very important is to understand that the way for the company, the dominant company, to implement predatory innovation is not, of course, to affect the product of one of your competitor. You have no power over that. You can only, as a company, do things internally. But the way you will modify your own product will eventually affect the product of your competitor. And you have two effects. One, it could be that the product of your competitor won't be fully integrated anymore, or that it won't work as it should. The second type of predatory innovation is basically everything which is not based on platform. So here it could be obviously softwares, now smartphone app, and so on. It could also be hardware. And we have a few examples where some companies with a fruit name changed the charger of their PC. And actually, the new version was bigger, and it took longer to actually recharge your PC. So here, it could be potentially predatory innovation. So here again, you won't alter the technology or the product of your competitor. You will change your own, and it could change the compatibility or the way your competitor product works on your platform. And the end result is pretty much the same. So question, where do we see predatory innovation? So first, I haven't listed that for sake of time, but we do have a few cases, I would say probably 15 cases in the US, saying that predatory innovation as such is illegal, and in some cases they actually fined the company, and in some other cases they just said, fine, good to go. The list that I'm about to show you, I'm not implying that everything is illegal, but that potentially it should be practices that competition authorities should have a look at, but they haven't. So I won't go through all of those examples. I'm more than happy to share the slides and to discuss after we are done with the panel. So you have all of those examples. Obviously, I took those companies. You see Twitter, Facebook, and so on. Yes, I should disclose I never got paid by any of those companies or competition agencies. I think the last one is interesting. The Apple and Samsung, they were actually fined by the French government for slowing down their phone. So here it's a way for them to actually do something which is predatory, but on their own product, and hoping that because your consumer is locked in your product anyway, if they have like now about phone, they will buy the new version. So it could also be that sometime, of course, when you hear predatory pricing, we understand that, but also innovation, sometime it could be a way to actually make your own product not as good as they were. So those examples, if you enter a few keywords, I've done that using the website TechCrunch, which is a website in the Silicon Valley with all of the tech news. If you enter compatibility or interoperability and all of those keywords, you will find millions, maybe not, but a lot of articles published on a weekly basis discussing those issues. The Google cases. The Google cases, of course, we have numerous issues. Maybe you mentioned some of them. Proof to consumer harm, I'm not so sure where it is. The counterfactual is not there. The legal test being applied, it's not clear, but I'm not here to discuss all of those issues. When I first heard about the Google cases, I thought, all right, this is probably the case I'm waiting about. And the case where one authority, in that case the European Commission, will say, Predatory innovation, whether or not they use that label, I don't really care, is something that is illegal. And actually, in none of those three cases, they look at that. The only thing they look at are contractual relationships, because of course it's easier to understand. Although if you look at the shopping decision, they did say that Google was potentially, again, I'm not sure this is true, but potentially demoting rival comparison shopping services. Now the question I'm asking is that purely contractual? Maybe they were doing that with a contract, but maybe also they were doing that in a technical way, but the European Commission is silent. Same for the Android decision. I thought that one, for real, they will discuss predatory innovation, where they say, well, the anti-fragmentation, which is really something technical, but still, if you read the decision, they don't mention product design, the technical issues of the way you design your product. The Google AdSense, of course, we're still waiting for the decision. Maybe we're going to have to wait for a few more years, who knows. But apparently nothing will be related to predatory innovation. So I think this is a missed opportunity. Again, I'm not here to argue that Google did something here illegal, but I think it was worth checking and investigating those issues. Legislative proposal, I just wanted to mention that. I've been working with a few parliaments. It has actually been introduced before the Italian parliament, a bill regarding predatory innovation, but I think the bill is kind of dead, and I'm not so sure how it works here in Italy regarding when the legislature is changing. Another one was introduced in Belgium, and I can't really tell you which countries, but a few other countries in Europe are working to say, of course, Article 102 is broad. We could actually catch predatory innovation under Article 102. But just so you know, companies, we are going to have a look at predatory innovation and the way you design your products. The reports. I don't know, Philip, if you heard about the CMA report. I was told it's a good one on the right. But the report, so they did kind of mention that without using the term, but the ACCC is saying that design features could be problematic, especially if it is a way to take more data out of consumers and to reduce their privacy. The Kramer report says, and here in the context, if you read it's a bit clearer, that rules and institutions by big companies should be in a way that is good for competition, but they do mention in those paragraphs the idea of technical product design. And in the same reports, they do say, and I really like that idea, and actually I think when we discuss network effects, we always say there are direct network effects and indirect network effects, sure, but also I think it's important to mention that some of them are voluntary network effects. So you implement that in the way you design your product. And I think this is a really good idea, and obviously it could eventually lead to predatory innovation. So to be a bit more, to open a bit the discussion, so when I was doing that work, I was looking for European decision discussing those issues. If not the keyword predatory innovation, again, I don't really care, but those issues and the way companies, they design their platform, their software, or their product. And I didn't find any decision. And in fact, I've been discussing that to several competition authorities, and apparently there is no decision regarding those issues. So is it a sustainable situation? I would argue that it is not. First, because of course, if you are a company, you could do predatory innovation, but it could actually be that you design your product in a way that it is easier for you to then do the things that we know, tying, predatory pricing, and so on. Second of all, they miss out on new practices, which are outside of what we know already. And the third, and I think this wasn't very important, I think it's basically a way to say to companies, if you want to do something illegal, if you do it in a contract, that we understand, so don't do it there. Do it in the way you design your product, because we can't have a look at that. And I will come back to that issue, but I think this is a major legal loophole, and this is really important to actually close the hole over here. So, of course, it's a big challenge, and what we don't want is for competition agencies to go to any companies and to say, this is exactly how you should design your product, this is the good way of doing it. That will be a nightmare. There is a huge risk of legal errors, whether it is type 1 or 2. The error cost analysis, of course, if you have to spend tons of money to actually investigate one small change in a product, it's not so worth it. But I think the urgency is in hiring people. And that's the reason why I have some ballet here. I think it's a really good thing that as lawyers we actually welcomed economists into the dance, so we have this duo. But I think it's a good idea if we make the geek enter competition authorities and to hire computer scientists and coders and developers. And I know that some agencies in the UK are going toward that direction, but I think it is needed. Otherwise, yes, it's a complicated issue, but how can you deal with it? It's complicated if you don't have the expertise in the first place. I'm probably already super late. What time is it? No, okay, doing fine. So that was the first part. So I think just to say in a nutshell that the way companies design product could be anti-competitive. There is no decision. Maybe some competition agencies, they have a look at it and they decided it wasn't worth it. I have no idea, but I think it creates a legal loophole that we should close. And then I want to introduce a new way to look at competition and eventually explain how the two comes together. So you may be familiar with that idea of code is law, but I will present that very briefly, and then I will explain something which is law is code, which is linked to it obviously, but which is a bit the reverse way of seeing it. So code is law. So I don't know if you read that book. It's an open source book. This is the second version. It was published first in 1999 and then the second version in 2006 by Lessig, who's a constitutional scholar at Harvard University. And his idea was to say that the way platforms and software are designed will actually change the way we use them, which is pretty easy to understand. If a social media was to put like a huge button on the first page with a published video and a very tiny button to publish pictures, of course we will publish more videos than pictures. So it was his basic idea to say, again, the way we design everything on the cyberspace will change the behaviors of the users. And I think and it relates to the CMA saying that companies could actually implement network effects in their product. And I think I really like that. The idea is to say that the nature of technology is not God will. It's the way companies decide to design technologies, and so we should have a look at that again. And so as such, code is law, meaning that the way you code the platform will actually have an effect on users as the law outside of the cyberspace, where you will actually say, maybe I should do that or not if it is legal, but in the cyberspace, the same is true for the code. But all of that is passive. It is just a way to say, I'm going to have a look, I'm going to have a step back and see what's happening. Oh, now we understand that behavior equal that design of the system. I also wanted to mention those two. The first, I really like that one by David Clark, who's one of the creator of the internet. I don't know if it means something, but it says, we reject kings, president, and voting. We believe in Roth consensus and running code. And you have the same idea by Satoshi Nakamoto, and of course I do have to mention the work blockchain. I've been obsessed with that. So he's the guy who designed Bitcoin and blockchain for the first time. And he was told, and we have those emails, he was told, to believe that you can solve issues with the technology is a silly idea, and his answer is to say it's probably true, but basically we can earn a few years of freedom without the government. So again, it's the same ideas that the code is really, really powerful. And blockchain, if you go to the forum back in the days when they were designing the technology, the main purpose was to avoid governments getting in. It was designed for that reason after the financial crisis. So as such, we find the idea again of that the code will give you great power and that the code is law. And so that potentially we should have a look at that. But again, all of that is passive, is saying what's happening, can I understand the codes, and then eventually you're going to try to do something to enforce the law as we know it today. On the right side, I don't know if you've seen that movie, but that's the end of the decade, so it's the time where we do the rankings, I guess, of the best movies of the decade. This one is good. It's Arrival. It was in the theaters in 2014. And it's about a bunch of aliens, I guess. They arrive on planet Earth and they communicate in a certain way that we can't understand. So they work with linguists to understand what they want to say. And I think this is exactly what we need to do with the developer community to understand what they want to say to us. So they are aliens in that story and we are the normal people. So my idea was to say, okay, maybe it would be actually a good idea to say we should translate the law and legal obligations into code. And then if they implement that into the design of their software and platform, because code is law, it will lead to legal behaviors in the first place. So we see a bit of that in the idea of regulation by design. But here again, regulation by design, it means either that you trust companies to self-regulate. So you say, you should design it in a way that is good for privacy and then find the way to do it yourself because I don't really understand. So I think this is still a bit passive. Another way of seeing it would be to say, I'm going to actually, as a legislator or competition agency, translate the thing for you and then create an incentive for you to put that code into your software. But of course, to translate the law is complicated. Sometimes it's quite easy. Predatory pricing, for instance, we know average total costs, variable costs, you could probably code that, but sometimes it's not so clear. It's not, black and white. So here, I don't know if and also it's a subject that is, I think, a bit technical, but I think the idea of quantum computing is interesting. To be very brief on that, on a computer as we use today, they work with the bits. So they work with the 0 and 1. So it's either yes or no. So if you code something, it has to be yes, no, and a bunch of that create a software. With quantum computing, we don't use the bit anymore. We use something called qubit, and where you could actually have an infinity of variables within only one element. So you don't need to have the yes or no. You could have all of the spectrum of all of the colors. So potentially, quantum computing will help in translating the law in a way that is more closer to our human analysis. But still, it's not easy. So I think it's actually interesting to think about the way we could translate the law regarding the 4 constraints which are raised by Lessig. And those 4 constraints, he argues, and I like that analysis very much, are the 4 constraints that will actually govern human behaviors, whether it is on the internet or outside of the internet in the real space. The first is the law. Obviously, if the government is telling you to go on the road that fast is forbidden, you have an incentive not to do it. So potentially we could do that. We could translate those legal obligations where it's very much command and control. It's clear what you should not do, what you should do. Potentially we could code a few of those obligations. The second one is the architecture. So the architecture, it's the way we design stuff. So the way you design a city would change the use of the city. The way you design a platform would change the use of the platform. So here it forces us to think about the objective. What do we want to achieve when people use Facebook or another social media? What do we want those people to do on that social media, or the way they use it? So that's the idea of nudging, and of course I will come back to the danger of that, but it could be one solution. The third is markets. So it's the incentive for you to actually comply and to do certain behaviors. Note that markets could go against the law, by the way. If you have an incentive to infringe competition law because you don't fear sanctions anymore, the two could go against one another. But that also, we could translate that, create the incentive in the way we code obligations. And the fourth is norms. So here it's complicated. Norms is what is socially acceptable. You see that online there are some behaviors which are not socially acceptable. And it's actually very interesting to see that on the dark net, where they sell basically pretty much everything, the big forum where they sell, criminal activity and all that, almost all of them, they prohibit the sale of pornography with child. So because this is not socially acceptable. It's perfectly socially acceptable to pay for someone to kill another person. However, child pornography is not socially acceptable. So maybe also we could put all that in the way we design software and platforms. And I'm almost done. So now if I tie the two, predatory innovation and the law is code, I think first it's good because it forces us again to answer big questions. And I think if you read the reports, namely the three that I've mentioned, it is not so clear whether self-preferencing should be legal or illegal if we don't have an essential facility. I know that Margaret Vestager is saying that it should be illegal, but according to the law, if we go back to the Bronner case in Europe, probably it's legal. So actually, to say that we're going to code the law will force us to actually answer that question. Otherwise, you can't code anything. I think it's also a good idea because to some extent, it's going to be really hard and probably harder and harder to actually catch practices for two reasons. The first is detectability. If you can actually do a practice in a microsecond, how can you detect that? And enforceability, if we talk about blockchain and those technologies where it's very much decentralized, it's not easy for the competition authority or the government to go to one person and say, stop that practice right away. No one is in charge of it. So for those reasons, I think we do have to think about the law is code eventually. And of course, I mentioned that companies are the best equipped to do that. Actually, it would be a good idea to start with, asking what would be the incentive for them to implement that law into their code and so on. And yes, to mention it's just another way to think about competition law. So at the very end, how cool is that? And it actually I did have to rewatch the movie just to take a screenshot. So this is Michael Caine, and he's entering a bank, and all of that are diamond. And I think this is very much what we should do. We should unlock technologies, understand technologies. By the way, when I say that, some people sometimes ask me, do you think it's a good idea for me to learn how to code? I think it's interesting. I know how to code a little bit. I'm not an expert, definitely not. But more and more with artificial intelligence, you don't actually need to code. You can actually enter the thing with our own language and it will be translated automatically into code. So I think technologies will help us eventually to start rethinking competition law more as an ally and less as a threat to companies, because I think it's going to be easier and easier for them to escape competition law. And I think that's it for me.